Okay, the first item of business is the election of chairman. Do we have a nomination for chair? Councillor Allen.
So good afternoon, everyone. Welcome to this meeting of the licensing panel. I'm Councillor Nick Allen, chairman of the panel today to consider the application for the variance of the premises licence for the Vault 327 19 High Street, Crowthorne. I'd like to start by asking everyone to introduce themselves, starting with the panel members.
Councillor Kath Thompson.
Would you use your microphone, please?
I'm Councillor Moira Gore from Winkfield and Moorfield East.
Good evening or afternoon. I'm Donald Adams, legal advisor to the panel. My role is to assist with any legal or procedural points or points of clarification that may arise.
I'm Emma Dearsley. I'm clerk to the panel. Thank you.
Katie Bourne, DPS.
Louis Stirling, solicitor for the applicant.
Yeah, Darren Brownlee, licensing enforcement officer for Public Protection Partnership.
Thank you. Item 2 on the agenda is a standard item relating to the declarations of interest. Would members of the panel please confirm that they have no disclosable pecuniary or affected interests in the application before us this afternoon?
Nothing to declare. Nothing for me either.
And I will also say I have nothing to declare. Right. Item 3 sets out the procedure that must be followed for hearings considered by licensing panels. For the purposes of today's meeting, I will quickly remind everyone of the order which we will follow today. First, I will ask the licensing officer, Darren Bramley, to present his report in respect to the application. Everyone will then have the opportunity to ask questions of the licensing officer. Secondly, well, actually, we have no objectors, so they can't ask any questions. So finally, I will ask the applicant's representative to present their case for as to why the application should be granted. There will be the opportunity to ask questions of all participants. However, all questions must be asked through the chair, and there must be no cross-examination. Before we finish, we will confirm that the solicitor, on behalf of the applicant, and objectors have said everything that they wish to say in respect to this application. At this point, I will ask everyone to leave the room and the panel will make their decision in private. At this point, you are welcome to leave the meeting, or if you wish to hear our decision, you may stay and be readmitted by our clerk. The panel's decision will also be communicated in writing to all parties within 2 working days and will be published on the council website. Okay, the purpose of this item 3, the purpose of this item is to determine application for the new premises license for the Vault 327 19 High Street, Crowthorne. Along with the agenda papers, a supplementary paper was published, which you should all have received. Before we begin, I must ask whether anyone feels there is a reason for an adjournment in this case. Okay. Mr. Bramley, can you confirm that all the formal requirements in respect to this matter have been complied with?
Yes, I can.
Okay. If we're all ready, I will ask Mr. Bramley, the Public Protection Partnerships Licensing Officer, to present the report.
Thank you. Good afternoon, everyone. My name is Darren Bramley. I'm the licensing officer with Public Protection Partnership, and I will introduce the application. On the 8th of October 2025, an application was received from Rondell Trading Limited to vary a premises licence under the Licensing Act 2003. The address for the premises applied for is the Vault, 19 High Street, Crowthorne, Bracknell, RG 45 7AD. The application has been recorded on the licensing database under reference number 24648. The application was validated on the 8th of October 2025, with the consultation period starting on the 9th of October 2025 and ending on the 5th of November 2025. Responsible authorities were notified of this application on the 10th of October 2025. The application was advertised in accordance with the Act, with the relevant blue notices being displayed at the premises and a notice of the application being advertised in the Bracknell News on the 22nd of October 2025. For the benefit of the members, the Licensing Authority have created a series of photographs of the premise showing the location of the premise. This is attached as Appendix 1 to 4. For the benefit of the members, the Licensing Authority have created a map of the premise showing the location of the premise. This is attached as Appendix 5. A copy of the current license can be found at Appendix 6. The current license is as follows. Opening hours of the premises, Monday to Sunday, 12 till 2300 hours. Supply of alcohol, on sales only, Monday to Sunday, 12 till 22:45 hours. There are no non-standard timings. Copy of the application form is attached as Appendix 7. A copy of the premise plan is attached as Appendix 8. In summary, the application seeks to vary the premises in the following way. Updating the name of the premises from The Vault to The Vault 327. To extend the opening hours of the restaurant from 12 till 2300 hours, Monday to Sunday, to Monday to Thursday, 0800 to 2300 hours. Friday to Saturday, 0800 to 2400 hours. Sunday and public holidays, 0900 to 2300 hours. New Year's Eve, 0800 to 0100 hours the following day. To extend the hours for the supply of alcohol for consumption on the premises from 12 to 22:40 hours, Monday to Sunday to Thursday, 10 to 22:40 hours, Friday to Saturday, 10 to 23:45 hours. New Year's Eve, 10 to 00:45 hours the following day. To provide late night refreshment from Friday to Saturday, 2300 to 23:45 hours, and New Year's Eve, 2300 hours to 00:45 hours the following day. To play live and recorded music from Friday to Saturday, 2300 to 23:45 hours, New Year's Eve, 2300 hours to 00:45 hours the following day. To modify the premises plan to extend the area to be used for the sale by retail of alcohol to include table seating for 12 people on the forecourt, an area of the pavement privately owned under the freehold title BK 24505, situated directly in front of the restaurant facade. The forecourt will be used for sit-down dining only, will be closed at 2200 hours on all days, and will not be used for the playing of recorded or live music or any kind. Service of alcohol on the forecourt will cease at 21:45 hours on all days. The application also seeks to vary the following licence conditions. Condition 9 of the current licence, the licensee must conduct regular risk assessments on noise levels outside the premise to ensure that noise from music and speech arising from the premises shall not be audible outside the premise or inside habitable rooms of noise-sensitive residential properties in the vicinity, to be superseded by proposed new operating conditions under the Prevention of Public Nuisance. Licensee will conduct a risk assessment in relation to noise emanating from the premises. This will be reviewed on an annual basis. A representative from the premise will conduct noise checks outside the premise from 2200 hours to ensure that any noise from music and or speech arising from the premise is not of such a level which would cause a nuisance to any properties in the vicinity. A representative from the premise will also ensure that noise from the external area of the premises before 2200 hours shall not exceed levels that would cause unreasonable disturbance or cause a nuisance. A noise limiter must be fitted to control amplified music and sound systems within the premises. The limiter shall be set at a level that ensures music is not audible beyond the premises boundary when doors and windows are closed during normal operation. The device shall be tamper evident and be regularly maintained in working order and set at levels which is agreed with environmental health. All amplified music equipment shall be connected through the limiter. Records of any maintenance or adjustments shall be kept and made available for inspection by authorised officers upon request. The premises shall implement and maintain a comprehensive noise management plan, including regular monitoring of noise levels by designated staff members. Logs kept under this plan should be made available to the licensing authority upon request. Condition 31 of the licence. states alcohol supplied for consumption on the premises will only be served in conjunction with substantial food orders. It's to be superseded by proposed new operating conditions under the Prevention of Crime and Disorder. Section 3, alcohol for on-premises consumption will be served with substantial food except to customers with reservations taking drinks before their meal, to customers finishing a meal taking drinks afterwards. Pre and post meal drinks are limited to normal dining hours and available only to dining customers, not walk-ins. 32, which is vertical drinking will not be permitted. This is to be superseded by proposed new operating conditions under the Prevention of Crime and Disorder. Vertical drinking will actively be discouraged by staff, save for when the premise is being used as part of a private event, function, or hire of the premise. And lastly, 34, which states orders for food and beverages may be made via waiter service or at the service counter. The placement of orders at the service counter will be managed by orderly queue. Consumption of drinks at the service counter will not be permitted. This is to be superseded by proposed new operating schedule 4 under the Prevention of Crime and Disorder, which states orders for food and beverages may be made via waiter service or at the bar. The placement of orders at the bar will be managed by orderly queue. Consumption of drinks at the bar is only permitted for customers awaiting their dining table or for those who have finished their meal. No representations were made by any of the responsible authorities. However, 3 valid representations were received from members of the public. The representations were made in the belief that the granting of this new premises licence would undermine the licensing objectives, namely prevention of crime and disorder, prevention of public nuisance, public safety, and the protection of children from harm. The representation was predominantly in relation to the prevention of public nuisance with noise being generated from the premises and the prevention of crime and disorder with concerns over the hours of operation. These representations are attached to Appendix 9 to 12. A representation was also received from the local parish council. The representation was predominantly in relation to prevention of public nuisance with concerns over the hours of operation. This representation is attached to Appendix 13. As the relevant representations were made, members must determine the application. Members must consider all representations, both written and oral, with due regard of the licence and objectives, and decide whether the application to vary the premise licence should be granted or rejected. Members are minded to include any additional conditions other than those offered by the applicant. They will need to provide their reasons for doing so in the decision notice. Licensing authorities should only impose conditions which are necessary and proportionate for the promotion of the licensing objectives. In addition to this, it was stated that any condition attached to the licence should be enforceable. Thank you. That concludes my report.
Thank you, Mr. Ramley. Good report. Right. So, panel members, are there any points of clarification you wish to make from the licensing officer? Maura?
Yes, to do with the supplementary report rather than what you've just said, because there was something that I wasn't clear about. So in the supplementary report, it's got about applying conditions to a TEN in terms of it's not valid to apply conditions to TEN.
Yes, under the Licensing Act, we don't apply conditions to a temporary event notice. They're typically only available to us if an objection is put into the temporary event notice, and then negotiations can take place, and then we can put put conditions in.
So can I just confirm that the conditions that are normally applicable to the premises wouldn't apply to a TEN, or they would?
They wouldn't. No.
They wouldn't.
No, they wouldn't for that period of time that the temporary event notice is in place. Yeah.
Thank you.
Councillor Thompson, do you have any questions?
I was just thinking that, the licensee were conducting a risk assessment in relation to noise on an annual basis. Do you think we should be doing that more often?
Appreciate that's not my specialty of Phil, but typically I would look to visit a premise once a year. So as a licensing officer, I would sort of draw any questions then. And then, I mean, if any complaints were arising or issues were arising, then they could be addressed then anyway. So, yeah, it's.
Just back to your report again, you indicated that that your report might have been different if the supplementary information had occurred at an earlier time. Does that have any implication to your view?
No, at the end of the day, there was a complaint that was made in relation to noise, and just the fact that the CCTV couldn't be provided, that just draws a concern in relation to the running of the venue, and that's as simply as that. On this occasion, that would represent a breach of the premises license.
Okay, thank you.
I have a question about the environmental officer mentioned that the Prince and the Crowthorne Inn have similar times. Are there any other establishments in Crowthorne that have Friday and Saturday an extended hour?
From a research, yes, the Hall and Woodhouse restaurant is 0700 till 0030 hours. And just to confirm, the other Crowthorne is Thursday through to Sunday, Saturday. So that's Thursday, Friday, and Saturday is 12:30, and the Prince is Friday and Saturday till midnight, 11 a.m. till midnight.
Thank you for that.
Sorry, Chair, could I
That's
just
right.
clarify? You mentioned and the applicant's solicitor may be able to clarify as well in terms of the sought variations. You mentioned variation to the condition 34. Just looking at the agenda pack on page 10, it seems to stop at 32. So I just wondered where the reference to 34 is that being sought, and you can clarify.
It is being sought, yes.
Thank you.
Apologies, there is a fourth venue in Crowthorne, Don Benny, which is an Italian restaurant that's open till midnight as well. So you've got four venues open till midnight.
That's interesting because the environmental officer seems to think they closed at 10. So, oh, mind you, there's a difference between closing at 10 and being licensed till 12, presumably.
Well, no, well, in theory, no. The license is
The license is till 12.
The license is
Yeah,
till 12.
Yeah, that doesn't stop closing at 10. But
No.
I suppose that might
And you appreciate
that might be where a discrepancy comes.
Yeah, there
okay,
is a
got it.
difference between some venues.
Yeah, thank you.
Yeah.
So the paragraph 34 was about awaiting people who are waiting their tables and who have finished their meals, buying drinks at the bar and being allowed to stay at the bar to drink. Was that correct?
I'll just go over it. So the 34 states orders for food and beverage may be made via waiter service or at the service counter. The placement of orders at the service counter will be managed by orderly queue. Consumption of drinks at the service counter will not be permitted. So in theory, from a practical point of view, you couldn't go to the bar, order a drink, and then take a sip of that drink there at the bar. So to be superseded by So the superseded bit is orders for food and beverages may be made via waiter service or at the bar. The placement of orders at the bar will be managed by orderly queue. Consumption of drinks at the bar is only permitted for customers awaiting their dining table or for those who have finished their meal. So, like I say, 34 would, in theory, the venue would be in breach of their license if they allowed someone to purchase a drink at the bar and then take a sip, which I regularly do once I've purchased a drink, before I then walk to my table. Whereas condition 4 would alleviate that.
However, it does leave it open to the fact that if someone's finished their meal at 7:30, they could still be there at midnight drinking.
That's correct.
Mr. Selling, or anyone on behalf of the applicant, do you have any points of clarification of the licensing officer?
Nothing for the licensing officer, Chair, no.
Thank you. Normally at this point we would go to the objectors, but there are no objectors in the room. So what we will do is the panel have read the objectors' comments and will take into account their representations when we make our decision. If we're ready to move on, so Mr. Stelling, will you please outline the case for granting your application?
Thank you, sir. I will start by going over some of the points in relation to those objections, and I will use the reference as per the report going on page 59 and 60. As to objection 1 from a Mr. Holmes, I believe, Mr. Holmes's objections seem to allege that the Vault is trying to become a club. Now, we are wholly sympathetic with local residents' concerns. We've heard there are lots of licensed premises in the area, and we've heard that we are at the moment a slightly earlier closing than some of those. But the applicant would seek to assure the panel that in no way, shape or form are we trying to become a club. Clubs don't tend to close at midnight, nor do they finish licensable activities at 11:45 should this application be accepted. We don't want to be a nightclub. We don't want to give a nightclub vibe. The premises is a food-led premises. I will come on to a potential compromise and or discussion in regards to the point that you made, Chair, in regards to finishing at 7 and drinking until midnight. It's a very valid point, and it's not one that I think the application dealt with entirely. I hasten to add at this stage I didn't draft the application. However, it's a wholly valid point. Unfortunately, a lot of Mr. Holmes's objections otherwise, such as how are we going to make sure that parking isn't an issue? How are we going to make sure that because the village doesn't have a substantial community presence, what we will do to regulate the behaviour of our clients? It's incredibly difficult to do it and almost impossible to prove a negative. There have been no complaints or issues in regards to our customers' behaviour in the time that we've been licensed. What we have is some noise complaints, which I will come on to, but the premises has a door staff externally after 10 p.m. To try and manage the exit of customers, because they are well aware that they are in a small community, a village. Should that need to become 9 p.m, I'm sure the applicant would seek to engage with that. But other than that, as I say, we are not seeking to become a nightclub, nor will they ever. Objection 2 is Mr. and Mrs. Taylor. And again, the noise issue is here. We've heard from the licensing officer, and you will see in the supplementary agenda of 2 noise issues in the time that the premises has been licensed. And I'll go on to how we're engaging with dealing with that later on. Objection 3, which is from Mr. Kapoor, again, similar thing, one element of noise. Again, we're wholly sympathetic. We don't want to be a premises that attracts noise complaints. We have got noise limiters inside the premises, and the doorman has an external noise recorder, which will alert him if it becomes overly loud. Environmental health very often say, because it's quite difficult to do this, use the ear test. If it seems too loud for you, go inside. But that's quite vague. Who's deciding what is too loud and what is on an ear test? He might be a very experienced doorman, but he might not know particularly bass or whatever else. So they have a handheld decibel recorder, and I can show you a photo of what that is. It goes beyond me in terms of technical, but they have that on their person at any one time. We don't have a doorman in place because we are a nightclub. We have a doorman in place because we are very aware of the situation and the context, ensuring clients leave, ensuring their easy egress, and noise, specifically within trading and licensable hours. The two noise issues complaints, and you'll see in the supplementary agenda, we have one in August of this year and one more recently. In September, post the August issue, there was an event which the applicant in this matter had originally sought to organise a temporary event notice for that time. The temporary event notice didn't actually go in. A third party had said organise the application, it didn't go in. Regardless of that, there was some confusion, and the applicant at the time couldn't tell you whether or not they had gone over the permitted hours. They didn't think they had. However, noise issues were reported and they met and engaged with the local authority, and you'll see in the agenda that it was discussed, and the first time issue, full explanation provided, something to go away and work on. The more recent issue, there was a 10 on the 7th and 8th of November, a couple of weeks ago, to extend the opening hours, which was granted. At 1:06 a.m. on the 9th of November, so the day after the final 10, a complainant provided a mobile phone video as evidence of noise, they say, emanating from the premises. To deal with that, first and foremost, and I spoke to the licensing officer briefly beforehand, the applicant hasn't seen the video. That's not one way or another, but they've not seen the video. However, we understand why the licensing authority say it's probably emanating from there. Can't be sure, but it's probably emanating from there. We are currently discussing it with staff who were there tidying up, cleaning up. The last till receipt for that evening was around 11 p.m. In line with the 10. So it was compliant in that nature. The applicant is adamant that there were no customers on site. Regardless of that, if a staff member was playing music that was audible in a neighbouring property, that is an issue. We're not looking to sway away from that, and we are talking to the staff who are present there and then. The compounding issue here is the lack of CCTV, and the applicant is well aware of the seriousness of this. Late October of this year, when they were investigating an internal issue with a staff member, it had been reported that the CCTV wasn't functioning properly. The security firm who provide the CCTV and the backups are called Zenith. And I believe, Dan, have you spoken to somebody from licensing might have spoken to somebody from there? Yeah. Unfortunately, as you can see, CCTV is not available then. We would love to provide it to ascertain exactly who was responsible and to demonstrate that no customers were there at the time. We can't do that. But more importantly, most importantly, to the tune of well over £1,000, the premises have had a new system installed, a new hard drive backup installed, and Zenith will be doing 3 monthly checks. So every 3 months they'll come, do a check of the physical system, do a check of the hard drive, and we are essentially on a new customer plan to try and mitigate those issues that, as I say, have absolutely compounded the November 9th complaint. We are not seeking a huge amount of extra time. We are, by and large, in line with other licensed premises in the area. As I say, we are a wholly food-led situation. In relation to one of the points raised in regards to the annual noise assessment, we would quite happily submit that we will do a quarterly one. Now, we're not suggesting that licensing have the bandwidth to come and do that per se. We would do it. We would do our logs, as we are now required to do. We would submit them to licensing on a quarterly basis. If there are any issues, if a type of music, for example, because different music create different noise issues, and we will have to submit those logs on a quarterly basis. Licensing can then see if there have been any issues. We can't tamper with those. It's a tamper void system. And also the SIA doorman can report in, and we will log any noise reports he makes in our incident report. It is a self-policing issue. And I appreciate that. And I appreciate the licensing and responsible authorities can't be hovering over every licensed premises. But you would expect to see in a self-policing event that there will be some incidents, that there will be some times when he pops in and says, it's quite loud, actually. What, you know, is there something to do with the music or whatever else? If the incident report shows nothing for a long period of time, that's probably because it's not being done properly. And so the venue is absolutely advised to do that and to do it properly, because licensing will be able to see if they're not. So that's it's sort of over to licensing to review those. At this stage, I don't believe I have any further submissions. If there are any questions for me and or indeed Katie, the DPS, and or indeed Mr. Rondell, the license holder, now, please.
I'm sorry, Joe. I think at the start you said you were going to make a suggestion in respect of variation 34.
Yeah, well, I'm a suggestion. I suppose I'd need to take specific instruction, but I think really a time limit on post a bill for the meal being received. So that, Chair, that doesn't happen, as you say. Although a reference is made to a large bar area, you know, we're not a huge pub. We don't really have the ability to have lots and lots of people milling around, because obviously covers are going to come in and more people are going to be coming into their tables. And so that doesn't really happen, but I do accept your point. So if the panel would be minded to impose a time limit post the bill being taken for the meal, where they finish at the table and go to the bar, I can certainly discuss it with my clients and seek an engagement there. I'm not sure on a relevant time period. I'd have to take instruction, but we're certainly willing to discuss that, yes, and add it to the conditions.
And would that equally apply to outside?
Yes, well, I mean, yes, absolutely. I mean, outside is a much earlier finishing time anyway, 21:45 as to this, but it would the same period of time. Yes, absolutely.
Well, thank you for that. Panel members, do you have any questions of the applicant?
Yeah.
Okay, Councillor Gore.
It seems to me that the reported noise issues have happened generally when you've had a 10 in place, and I wondered what the conversation is between you and whoever's running the event, because at the end of the day, you pick up responsibility for things that aren't correct, and there seems to be, in one case they didn't know, in the other case there's confusion with recording equipment.
Katie will give you some more information. I think certainly in this latest one, we have staff on the premises later. And as I say, we do believe it was a staff member. They're at the premises later, they're cleaning up, they're cashing up, they're doing all of that stuff. And we think they had music on. And simply they were there later. Whereas at the moment, outside of the 10 event, they're not there at 1:06, because well before midnight, as it would be, or currently now, that process starts a lot earlier. And as I say, we're discussing it with staff at the moment, especially about this, because we're trying to corroborate what the issue was and why it happened. But Katie could probably give you some more information about that closing down process.
Thank you. The 10s were only actually put in place so that we could get in ready for if this was granted. This is actually the only reason. We haven't had any special events on whatsoever. We literally applied for the 10s so that we could say, hey, we're already doing it, you know, and that you could see where we are a reputable business, and that we literally just want to give our diners a really, really nice dining experience with fine wines, a nice environment, and then a good evening. That's it. Thank you.
So the other question really was around this CCTV. I appreciate what you've said going forward, but in terms of the provision of 31 days worth of footage, etc. It is a licensing requirement, and I just wanted to be sure that it sort of sits as a prominent feature in the building, because there seemed to be I might have taken it the wrong way from the email exchange, that there was more focus on missing money than actually resolving the licensing objective, which seemed to be pushed. It's Zenith's fault, or it's, you know, someone's on holiday or whatever. The DPS is meant to, you know, act quickly and robustly and efficiently to make sure that sort of thing doesn't happen. And I'd want to be sure that learning the lessons from the recent cases, that we'll never have that issue in terms of either equipment or practical effort.
I completely and utterly agree, and it was my fault that I didn't alert them quick enough. He was actually away and said that he would look into it when he gets back. And it has been a big learning curve for me, to be honest. And actually, the loss of the managers that were there has actually forced me to be in the premises consistently. So I've actually really noted down a lot of issues within the team, things like that. So yeah, I'm moving forward absolutely going to make sure that everything is ticked and crossed, and yeah, so that I can fully concentrate on elevating the business as a whole, and, you know, helping the wider community and so on and so forth.
I just want to go on a supplementary on the CCTV, because it's disappointing that even though you said it was 7 days, you were only recording 7 days instead of 31. The fact that the licensing authority came to you within 48 hours and said, can we see the CCTV footage, which would still be within the 7 days, and then they still didn't manage to get CCTV footage in that period, because by the time you'd gone back and forth on the emails, I think your 7 days had gone. So I'm a bit concerned that it took so long to get through that discussion, rather than just saying, oh, look, we found the CCTV footage.
Again, that is my fault. I wasn't up to the technical knowledge and wasn't aware how to use the CCTV and to send forward emails and so forth, that I'm now taking in-depth training for. I'm not a very good technical person when it comes to things like that. On a phone and email, I'm not very good. I will hold my hands up. All I'm doing now is learning and educating myself. So moving forward, I know exactly what to do, exactly how to get across the emails and to get these files across. I was unaware how to do it at the time. And I can only hold my hands up and apologise genuinely. Like, I can't do anything more than that.
No further questions at this.
Not on CCTV now, but on the outside table seating area. I think that it's natural that people will want to linger, you know, summer's night, etc., etc. How are you going to make sure that there's no that a crowd isn't attracted to that outside area, making a nuisance of themselves, apart from the doorman who's going to be monitoring the noise and doing all sorts of other jobs? How's that going to happen?
Councillor, just very quickly, the first thing that would deal with that is exactly what we have potentially proposed in regards to a time limit. So they must be seated for their meal. Service can only be while they're seated for their meal, and then a time limit would apply. It is not an area where people could congregate vertical drinking. That would not be permitted. It would be a seated area, vertical drinking there. And obviously we're a much earlier close. If people then do either sit on some of the supplementary seating, whatever else, it will be time monitored. And that would be a condition on the license that we would have to enforce. If we don't, we're in breach of the license. So as a mitigating condition immediately, we would propose something of that nature. And of course, then obviously the doorman. The doorman in terms of the noise, well, actually, because the doorman's on from 10 p.m. onwards, we'd have to adjust that to make sure he's there when the outside seating time limits are there, to absolutely help deal with that. But I don't think it would be beyond an SIA trained doorman to have an eye on the seating area as well as monitoring the front door.
Sorry to interrupt. Do you wish to take instructions on an offer of a time limit if they were minded to do that, or you want to leave that to the panel's discretion if they are minded to impose one?
I would leave it to the panel's discretion if they are minded, because we are very willing to engage with what the panel would suggest at this stage for the application as a whole.
I mean, I guess also on the outside area, I'm guessing you don't have a designated smoking zone. You do. So where is that in comparison with the building?
Okay, so that's actually around the side of the building. So it limits a lot of, people from lingering smoking. We also only allow 3 people out at a time to vape or smoke. It's quite a popular thing, but we make them go around the building and only 3 at a time, and then we tell them to come back in.
Yeah, I was just concerned that they'd be, when after 10 o'clock, they might be standing out the front of the building rather than round the side. But if someone's monitoring that, then fine. It also occurred to me that you talked about people waiting for tables. Presumably, if they turn up 2 hours before their table's due, that's a long time to wait. Presumably, you wouldn't you ask them to come back.
Chair, I'd say as part of the same potential condition, we'd put a limit pre and post. It's very difficult for us, as I say, we want to turn over covers. We want people sat down eating and drinking, not people having a supplementary couple of drinks afterwards. It's in the interest of the premises to turn over covers and to have people sat down. As I say, I think really at your discretion, if you think of a time limit, I can propose it to our clients. We can go from there. But in the context of the application, I wouldn't seek to sort of propose or enforce a time that we think is suitable. I think we're absolutely willing to listen to you and engage with that.
Thank you.
I just have one more.
Yeah, sorry, carry on.
This is just purely an informative. What is 327 and why is that being added to the name?
Okay, so we actually own another business, which is a petrol station, and I'm really superstitious. and the address is 327. So if we didn't have that to be able to fund this and to get us, the ball rolling and slowly taking the business to where we want it to be, I wanted it in there, so it's a bit more of a personal touch, really. It's not a code for anything, don't we?
Okay, Mr. Bramley, do you have any questions of the applicant?
No, I don't think I do now.
Thank you. Right. In that case, we'll move on to the final summing up. So as we have no objectors, I will ask Mr. Selling to sum up the case for the applicant.
Thank you, Chair. I won't go over everything that I've said, other than to reiterate the applicant appreciates that mistakes have been made. Specifically in November, they are seeking to resolve those with the licensing authority currently and have already made serious endeavours to ensure that it doesn't happen again. To reiterate, we are not attempting to become a club. We are a food-led premises. Hopefully, the panel can see that we are engaged, that we are taking steps. What I might further suggest, because I didn't do earlier, the applicant has also suggested that it become a condition that all staff hold personal licenses. Either we employ people with a personal license, or within 1 month of their start date, they undertake a personal license course. What that means is that all of our staff are trained to the highest qualification that a licensed premises can expect of a staff member. We are more than willing to do that as a condition on the license also. We are also willing for the smoking area to become a condition on the license in regards to the limited numbers as well. We police that as it is. And the more that we can do to demonstrate to you that we are bound by these conditions and that we're seeking to comply and promote with the licensing objectives, the better it is for us. We're trying to run a compliant business and one that serves the local community. Conditions aren't something to be dodged or something to be held over our head. It helps us be a better premises and provide a better service for our customers. Other than that, thank you very much for your time.
Okay, that brings everyone's contributions to a close. I will ask each person in turn to confirm that they've said all that they wish to say with regard to this application. Is that the case?
Yes, Chair.
And the licensing officer?
Thank you. Yes.
Okay. Right, before we finish this meeting, I'll ask our legal advisor, Mr. Donald Adams, to ask us advise us of any legal issues that need to be taken into account.
Thank you, Chair. Just pulling together a few themes that have been said. So this is an application to vary an existing premises license. I won't go into detail about all the different variations because they are listed in detail in the agenda. But just to summarise, it's seeking change of name to the Vault 327, the extended opening hours of the premises on the days and times that are set out in the agenda, the extending the permitted hours for the retail sale of alcohol for consumption on the premises on the days and hours as stated in the agenda, to permit the provision of late night refreshment, which is the provision of hot food and drink after 11 o'clock on those hours and days as set out in the agenda, to permit the regulated entertainment, which is the playing of live and recorded music during the hours, which is effectively, if you were to agree the extended hours, it would be for relating to hours after 11 o'clock on those days and hours as stated in the agenda, to modify the premises plan to allow the for the retail sale of alcohol to persons seated outside in the forecourt, and the applicant has offered conditions in respect of that forecourt's use and limitations and the hours of ability to use that. Also, the applicant is seeking to vary condition 9, but that relates to risk assessments. They've offered, as I think I've correct in understanding, they've offered quarterly assessments, and they've also offered further conditions which are set out in the agenda pack, including as to noise limiters and working with environmental health. Also seeking to vary condition 31, which relates to the consumption of alcohol with food orders, also to vary condition 32, which relates to the vertical drinking condition or precluding vertical drinking condition, but you've heard what the applicant said in respect of that. Also, as you've heard, sought variation to condition of condition 34, which relates to table service. So those are the sort of variations, and you'll need to make determinations in respect of each of them. As you've heard, this premises is on a high street. There are other licensed premises in the vicinity, including pubs, restaurants and supermarkets. You've heard representations in respect of the believed terminal hours of those licensed premises. There are, as is set out in the agenda, residential properties to the rear and side, and it appears from at least one representation that also opposite the premises. Your task is to determine whether granting this license, the variation to this license, does promote the full licensing objectives under the Licensing Act. As set out in the agenda, you have discretion to determine this application, having regard to everything that's been written and orally presented to you today. You'll also have regard to the provisions of the Licensing Act itself and the associated licensing hearing regulations. You'll also take into account the Home Office's updated guidance as issued under Section 182 of the Licensing Act. You'll also have regard to the Council's own statement of licensing policy. You'll also take into account the applicant's operating schedule, together with the mandatory licensing conditions that are already attached to the license, as well as any other additional conditions, including those that have been offered today, and any others that you would be minded to deem appropriate to promote the full licensing objectives. The overriding objective is to determine this application having regard to the promotion of the full licensing objectives under the Licensing Act. Those are the prevention of crime and disorder, public safety, prevention of public nuisance, and the protection of children from harm. Each of those 4 objectives is of equal importance. The application is to be determined on its own merits. The decision you make must be evidence-based. You do have the discretion in giving your reasons for doing so to amend or omit conditions or to impose additional conditions, but any conditions that you impose must be proportionate, justifiable, capable of being met by the applicant, and appropriate to the promotion of the 4 licensing objectives. Turning to the representations that have been received, you will note that there have been no objections received from any of the responsible authorities, including Thames Valley Police, Environmental Health, although Environmental Health have made comment, and Trading Standards. There have been 3 valid representations received from members of the public and also 1 from the local parish council, primarily relating to concerns as to potential for adverse impact on the promotion of the prevention of public nuisance and the prevention of crime disorder objectives if these sought variations were granted. Primarily, the concerns are over the potential increase in noise nuisance with associated risk of increasing crime and disorder due to the extension of the licensing hours sought. It has been said, it has been noted, and it has been commented regarding concerns over both the previously issued TENS and the availability of CCTV in respect of complaints surrounding those. You've heard from the applicant as to what their response to that is. You'll need to consider the likelihood of the licensable activities themselves adversely affecting the promotion of the licensing objectives, and to what degree, if any, provision to deal with such concerns is within the control of the applicant. You'll consider that the Licensing Act itself does provide for scope for review and or ultimately revocation of a licence as an ultimate check and balance should any complaints arise that are attributable to the licensable activity at this premises. There are also certain statutory provisions outside of the licensing regime itself, which gives powers to the police and other partner agencies to enforce against such issues as nuisance, public disorder, antisocial behaviour, irrespective of whether those issues can be directly attributable to the licensable activity at this premises, albeit that is subject, of course, to evidence gathering and resource considerations. So, panel, ultimately, as is stated in the agenda, you have discretion to grant the variations, the numerous variations, or any of the variations to the licence, subject to any exclusions or conditions you deem fit to impose in promoting those 4 licensing objectives, including those conditions within the operating schedule, the mandatory licensing conditions that already attach, and consideration of any offered or mediated conditions and any others you deem appropriate additional conditions to impose, or you can refuse the application for the variation. So that is your discretion. Thank you, Chair.
Thank you, Mr. Adams. Right, that concludes this panel meeting. The panel will now meet in private to make our decision. The decision we reach will be communicated in writing to all parties and published as the minutes of this meeting within 2 working days. When the panel meet to deliberate, the clerk and legal advisor shall be present with them to keep a record of proceedings and advise on points of law. They will take no part in the decision itself. Does anyone have any objections to the clerk and legal advisor meeting with the panel?
No, Chair.
Thank you for attending today. I would ask that basically if you can stay in the room and we'll.
We're leaving.
Yeah, we're leaving. Yeah. I will stay in the room and basically we will come back again soon. Our clerk, if you need to leave at this point, the decision will be communicated to you within 2 working days. Thank. would not have an adverse impact on the promotion of the 4 licensing objectives, which are the prevention of crime and disorder, public safety, prevention of public nuisance, and the protection of children from harm. In summary, the panel granted the new, the variation with the following conditions, which are in addition to both the mandatory conditions and those additional conditions which were set out in the agenda papers. With regard to condition 9, risk assessments shall be quarterly. With regard to condition 34, there'll be a 30-minute limit prior to the allocation of table and after paying the bill for food, both inside and outside. The smoking area should be limited to 3 people, and that personal licenses for all customer-facing staff should be obtained within 1 month of being employed. I would ask that you note that the decision letter will be sent to you in the next 2 working days, and this letter takes precedence over the oral decision I've just given you. The panel's decision is binding upon you and the licensing authority. If you are dissatisfied with the decision of the licensing panel in this case, you may appeal against its decision to the Berkshire Magistrates Court. Thank you all for attending today. This concludes the meeting.
Thank you.